Right. Hello. Very warm welcome to you all for today's webinar on the global pandemic, lessons to be learned for the shipping sector, which I think is something which is going to loom very large in our lives in the next few years, the implications for shipping. I don't know how long the pandemic itself is going to loom large in our lives, but it seems to have plenty of twists and turns left in it at the moment. I'm going to be your chair today. Dr. Regina Sariotis of UNCTAD was initially going to be the chair, but she has a very important meeting. She has to be there at 1300. So we're going to start with her presentation. Then I'll move on to Philippa Hopkins' presentation. Then I will introduce myself as chair and also as a presenter, and then finally on to Leah Amaxolati. Questions for Dr. Sariotis can be taken, if they're brief, directly after her presentation. For all the other three participants, the questions will be at the end of the final presentation, and I will look at questions coming in on the Q&A, and I will then be putting them to the panelists. So without further ado, I'm going to ask Dr. Oh, I must introduce you, Regina. I'm sorry, you're so familiar to us, but perhaps not so. Regina Sariotis is Chief of the Policy and Legislation Section, Trade Logistics Branch at UNCTAD, the United Nations Conference on Trade and Development. She's responsible for the Secretariat's work in the field of transport law and policy. Before she went to UNCTAD in 2001, she was a senior lecturer in maritime law and member of the Governing Institute of Maritime Law at the University of Southampton. She taught there for more than 10 years. She holds a law degree from the University of Augsburg, an LLM from the University of Southampton, and a Doctor Juris from the University of Hamburg, and is a practicing barrister of England and Wales, and attorney at law for Greece, as well as a member of the Chartered Institute of Arbitrators. So without further ado, having done that introduction, I'll hand you over to Regina, and I will mute myself.
Thank you very much, Simon, for this kind introduction, and thank you very much for the kind invitation to participate in this very timely and I think important event. As you said, there are massive implications long-term for global trade and shipping, and this is a very opportune moment to start considering some of these. So I'm going to start my presentation. If you just bear with me for 1 second till I'm set up here, and you will tell me if you can see it, and then we can get started. Just see. Can you see the presentation? Okay. So I'm going to start off with a little bit of a global perspective on some of these issues. As regards UNCTAD, just to say, it's the United Nations Conference on Trade and Development. So it's the UN focal point, the organization which is a focal point for the integrated consideration of trade and development issues, with particularly the interests and the concerns of developing nations at the heart, although our membership is global. And as one of the few sectoral areas where we're working is transportation, and that is because of its role in international trade. And that brings me to my first slide, really, because it's probably obvious to everybody here at this seminar, but it helps focus the minds to recall how critical a facilitator for global trade and development maritime transport actually is. Over 80% of the volume and 70% of the value of world merchandise trade goes by sea from port to port. And so shipping and ports are really key links in the closely interconnected network of international supply chains. Globalization means we are all interdependent and interconnected. And in terms of developed and developing world, seaborne trade, over 80%, over 60% of goods are actually loaded and unloaded in developing countries. So this is certainly a global sector, and is a global issue, or global issues affect the shipping across the world. And of course, the UK as a forum for dispute resolution and with English law very often chosen in commercial contracts is critical to global trade, not just in the UK. Among the wide-ranging socioeconomic and trade-related implications of the COVID pandemic and also the related response measures are those for seafarers and crew change issues. And that is very critical because, of course, the flow of supply chains, of goods through supply chains, and the running of global commerce is dependent on the servicing of these vessels, and that includes crew changes. So I'm going to say something about this in a minute. And then in terms of implications for commercial contracts, there are many types of contracts, but particularly if we're in the context of today, we're thinking of international sale of goods on shipment terms, CIF and FOB, and carriage of goods by sea, charter parties, bills of lading, and related claims. So on the seafarer issues, this is, we've been monitoring this, and there is a link here to a short article giving you a bit more information, but obviously to ensure food security, medical supplies, and provisioning of populations, and also to harness the benefits of a growth in e-commerce, physical supply chains need to be secured and kept open. So there was from the outset, sort of since the beginning of the pandemic, after a scramble of measures in response, there was a great deal of recommendations and guidance issued by governments, by international organizations, industry associations, etc., to ensure that seafarers are on the one hand protected and medically fit, have access to medical care, and that ships and port facilities meet international sanitary requirements. But border closures, lockdowns, and preventive measures have resulted in hundreds of thousands of seafarers stranded at sea far beyond the expiration of their contracts. And this has prompted calls by international organizations, industry bodies, and governments. You've got some links there, urging states to designate seafarers as key workers, accept identity documents as evidence of this status, and allow flexibility to divert ships to call in ports where crew change is possible without imposing penalties. And this topic has been acknowledged as of critical importance to global trade by the UN General Assembly. That's quite unusual. They don't often have resolutions on transportation. And in December last year, a resolution was adopted to address challenges faced by seafarers as a result of COVID to support global supply chains. Among others, this resolution urges states to designate seafarers as key workers, also other marine personnel, and to implement a set of protocols developed by the IMO to ensure safe ship crew changes and travel during the pandemic, and also calls upon governments to promptly implement measures to facilitate crew changes. That in turn has given rise to what is called the Neptune Declaration on Seafarer Wellbeing and Crew Change, which was adopted and then signed by over 600 companies and organizations, all major shipping companies and organizations included, of course, recognizing their shared responsibility and resolving to take certain steps. That was in January of this year. And the last information from IMO is that as of end of May, 63 countries, IMO member states and associate members, had signed on to designate seafarers as key workers. But that doesn't mean that there are no problems, and we're going to carefully monitor the situation. We've been asked to report to the General Assembly, and we'll do so as part of our upcoming review of maritime transport. That some of you may know this publication. It's an annual flagship report, and it will be published only in October or November. But we will have a chapter there or a section there on this particular issue. At the end of my presentation, I have another set of sources for you with hyperlinks if you're interested to follow up on some of these issues. Now to come to the other set of issues that I'd mentioned at the outset, and that's of course a topic for today, mainly key international commercial law implications. As a starting point, the unprecedented disruptions that are associated with the pandemic and its consequences give rise to a plethora of legal issues which affect traders across the globe. And the effects of these disruptions are likely to, in future, also lead to widespread business losses and bankruptcies, but also to potentially overwhelm the courts and legal system, which at a global level may have implications for governance and the rule of law. So in all cases, looking at it from a contractual perspective, where performance is disrupted, delayed, or potentially impossible, there are legal consequences. And that might give rise to the need for dispute resolution or potentially litigation, and gives rise to jurisdictional issues, again, given the global context. It's obvious that we need common and collaborative approaches to reduce the incidence of disputes and to facilitate their resolution. So if we're thinking of what traders can do, for example, in this context, the problem is, of course, people don't have the same interests. Different parties have different legitimate interests, but one would hope that there will be greater willingness to make contractual extensions, for example, and to show restraint in pursuing legal rights and claims, and also to pursue efforts at informal dispute resolution or mediation. And looking forward, there will be a need for equitable, fair commercial risk allocation through standard form clauses in contracts. And we've had this, if you recall, in the aftermath of 9/11, for example, with maritime security, a number of clauses developed, and now is another time for this. Some of the clauses that are being developed are primarily developed by ship owner organizations and accordingly favor those. And one has to, I think, look at this on the side of practicing lawyers as well, in terms of advice, to see how this can be apportioned effectively over time, looking forward. There are additional considerations which have to do with electronic affairs. So electronic trading in a physically constrained world, e-commerce obviously is going to grow significantly. But what people often forget, and of course lawyers are aware of this, is there is a difference between the contract, the agreement, and its performance. And the performance of these e-commerce contracts, for goods at least, relating to goods, are in the real world. So these goods still have to be manufactured, stored, distributed, and transported and delivered, which entails, of course, implications for physical networks and infrastructure. And that remains a challenge. As Simon has said, we don't even know how long this pandemic is going to continue, never mind the aftermath. So we're already seeing that cyber risks are increasing significantly as a result of a shift to virtual interactions at all levels. And that increases vulnerabilities across the globe. We've seen this very recently with the ransom attack on the pipeline in the US East Coast, if you remember, that halted energy supply to 40% or 40% of energy supply at the US East Coast. And there are day in, day out, there are really new reports. And it's very important that people take this as an opportunity to think ahead, and that coordinated efforts at protection against cybercrime are pursued with some urgency. That in turn is going to, of course, also require scaling up of investment and capacity, in particular in developing nations, of course, where this is often lacking, but not only. And everybody has to consider in their own environments what to do about this. But this is, again, something going forward is going to be important. As part of the UN response to the pandemic and to helping to build capacity to address the implications, we are collaborating with other UN organizations, the regional commissions, 5 regional commissions, on a project, on a technical cooperation project, which includes a component which focuses on commercial law implications. So key issues include disruption and delay affecting the performance of international sale on shipment terms, CIF, and FOB, and also contracts for the carriage of goods by sea and related claims, particularly cargo claims, not only, of course. So the types of issues, I'm not going to go into this in any detail. My learned colleagues are going to follow up on some of these issues, I'm sure. But some of these issues are, of course, delay and disruption. They're in relation to the issuance, availability, and tender of documentation. That includes certificates, which have to be, for example, certificate of origin, etc. But particularly bills of lading, which have to be tendered as part of sale contracts, and also to obtain delivery of of the goods from the carrier without incurring or giving rise to liability. So the presentation rule. And there's going to be significant delay as long as we need physical documentation. And as you know, there is the electronic alternatives aren't yet that widespread in use. NOR, Notice of Readiness, which determines when a ship has arrived, which is important for when the delay or the risk of delay shifts in voyage charters, is another example. Then actual physical shipment of goods in CIF and FOB, it's a condition, of course, of the contract to ship within the contract period. That is an issue. Then there could be actual damage or loss of the cargo, particularly in the case of perishable cargo, affects delays for loading and unloading operation, which again impacts on laytime and demurrage, and redelivery of time chartered vessels, again, where there are time obligations. So documentary and time obligations in commercial contracts under English law are typically conditions, and their delay, of course, can be of particular relevance. Then there are other issues like safe port warranty, deviation, seaworthiness, the documentary side there, which can all be affected, or where there can be implications for parties' rights and liabilities arising from the pandemic and its measures. So we've started by preparing 2 substantive briefing notes, and these were done for us by Professor Filippo Lorenzon, who you might know from Southampton University formerly. He's now in Dalian in China, and focusing on these different types of contracts. We're following up with that on this with 2 further reports to look at issues more in depth. And I'm extremely pleased that one of these reports is prepared for us by Simon Bowen, and I look forward to, we look forward to publishing this in due course. And in due course, we'll also organize some training and capacity building. Now, before this is just the only picture basically I have for you in this in the slides with a lot of text. So these are just links to these publications and to the project and to a policy brief which we've published last year. But before I hand over to the distinguished panel, let me just make one aside, which I think is important. COVID must be seen by all of us as a kind of cautionary tale, because it does illustrate how we all depend on well-functioning transport links, and how important early planning, risk assessment, preparedness is for resilience building. Just in general, this applies to future pandemics. We hopefully will learn some lessons, but it also applies in different contexts. And one area where we've been doing a lot of work over recent years is climate change adaptation for ports and other key transport infrastructure, on which the global trading system entirely depends. There's a high and growing risk of particular coastal flooding, and we've just published a little article on this with the latest information. There's also a link to our website. We've done some work, as I mentioned, over 10 years. And just as a glimpse here, I've put together, or put the bullet there, a Guardian report on Swiss Re research, so Swiss Re being one of the largest reinsurers, which suggests that the climate crisis is going to hit economies double to the effect of COVID. And if temperatures rise by 2.6 degrees by mid-century, and we're unfortunately on track for this, G7 countries alone will lose 5 trillion a year. So you can see that this is certainly something that needs action. And one would hope that the lessons learned provide an impetus for early risk assessment and foster long-term planning, which is essential to enhance resiliency and build back better. So this can be used as an opportunity also in the context of COVID recovery. And the last slide is just one figure for you. You don't have to study this in great detail, but let me tell you what it shows. This shows you extreme sea level projections for global ports under climate change. On the top left, you see the current sort of over a past 30-year period, 40-year period. You see what the 1 in 100 year extreme event is. So this is the type of event which is used as a design parameter very often for ports. And these are the levels on the in meters. And on the panels B, C, and D, you will see how more frequently these are expected to occur events of that strength are expected to occur under climate change. So 1.5 degrees is likely from 2030. That's practically next Wednesday. That's less than 10 years in the future. And where you see red, it means what used to be a 1 in 100 year event, maybe as several times per year, certainly once every 10 years, what used to be 1 in 100 event. And that, of course, gets worse. So by the end of the century, where we expect around 3 degrees, this could be several times a year. Long story short, there is an important need for action. And as I say, COVID, I think, should provide the impetus for doing something about it. And with that, I'm going to leave it. And I very much look forward to the presentations of my distinguished co-panelists. At the end of my presentation, I've given you a few more links. So with that, let me close. Thank you very much.
Thank you very much, Regina. Now, I'm looking at, I think there is about 7 minutes before you have to go. I've just got one question comes to me is, what's going to happen with vaccinations of seafarers? I mean, I don't know how that issue is being dealt with, and who's going to be responsible for giving them. I don't know if you have any information or as to the thinking on that.
Yes, actually, it's a very good point. I mentioned the Neptune Declaration,
Yeah.
And as part of that, these organizations also commit to ensure priority vaccinations of seafarers, for example. So this is something, it's not, there's a globally coordinated effort to advance this, although the responsibility is not with any one organization. But as I mentioned, I have provided hyperlinks so you can have a look at what the of the text. But you're right, this is part of it, because of course the seafarers have to be medically fit, and the safety of co-workers, etc., has to be assured. Otherwise, it won't work. So just like other key workers are priority candidates for vaccinations, so would seafarers be where they are classified as key workers.
I'm just wondering how, in the future, when we're going to see whether we're going to see requirements from ports that the ship's crew have got vaccinations, whether that may cause some problems.
That's an interesting question, although my guess would be we're not going to see a requirement as such, and that is because the majority of the world's seafarers is from developing nations, and as you know, it'll remain to be seen if and when there is going to be sort of a significant advance in vaccination of populations across different countries. As you know, in the UK, some other countries, the United States, there has been very swift progress with vaccinating large parts of the population, but that isn't the case at global level. It's in many countries, it's 1-2% maximum, if that. And so I would be very surprised if that were made a condition, because that would of course cause problems for many of the seafarers. But having said that, you're right. I think vaccinations, because it is the first step to normality and to ensuring this is going to be driven with some urgency, vaccination of seafarers.
Well, thank you very much for the presentation. There is, have I got a question? Right, I have a question. You've got a very short time. Okay. The question is, few ship owners attempted to purchase vaccines privately to proceed with vaccination of crew, but they were restrained by flag states. Now that's I find that quite interesting. I haven't come across that before, but I mean,
I'm not aware of this. I'm just trying to think what may be the rationale in terms of were prevented. It could just be that basically because of the rollout of vaccines, this was not going to be done through private entities. So you don't just purchase a lot, but it's sort of distributed through the public domain. That's the only thing I can think of, because otherwise, I mean, what's it to flag states if companies want to vaccinate their employees effectively, like in other industries as well? but I guess it has to do with the supply chains for vaccines and the, also obviously, in the case of some of the vaccines, as you know, you have sort of cold chains and so on. You've got the need for very low temperatures and so on. So you need some supporting infrastructure. Maybe that has played a role. I wouldn't be able to say at this stage, but certainly for my part, my email is up on the presentation. If anybody here has any questions particularly, I'd be very happy to follow up in due course if you'd like.
And I'd also like to thank you for highlighting the climate change implications as well, which is part of your work, UNCTAD. And if I wasn't depressed about COVID, I could certainly be depressed about climate change. So thank you very much, Regina. I think you've got 2 minutes before.
No, that's all right. I don't know if there's anything from anything else, any other questions.
Oh, yes, it was a follow-up from the question that the argument was that vaccination had to be done exclusively under state supervision. So I think that
exactly. Maybe that will change over time, but also we'll see, there's now talk of the need possibly for booster vaccinations or tweaking the vaccines for variants. So we'll see how this pans out over time, but that would explain in the first instance why there might have been a delay. And on this climate change, let me just say, the point is not to get depressed, because that won't help anybody. There is a window of opportunity, and that's both mitigation, but adaptation will be needed anyway. And one thing, we've been looking at this for many years, and people are not really aware of this because they focus on the direct damage rather than on the trade-related economic costs of disruptions. And that's really important. So we've got to get going on this topic either which way. And now is a time.
Yes. Right. Well, thank you very much, Regina. And I'm now going to introduce.
Thank you very much.
Our next, and remember, Regina has to sort of disappear for another meeting. So I'm now going to introduce our next panelist, who is Philippa Hopkins, QC. And Philippa was called to the bar in 1994 and has been a tenant at Essex Court Chambers, which is a leading commercial chambers since October 1995. And she took silk in 2018, and there's a couple, she's one of the editors of Arnold's Law of Marine Insurance and Average, and a contributor to the White Book, and she edits the sections on the commercial court and on arbitration, as well as she has an extensive arbitration practice, both as counsel and as arbitrator. And the couple of cases which highlight her involvement, she's been involved in quite a couple of recent ones, Takar Brutani versus Rockrose in 2020, J versus K, Lloyd's Rep in 2019, and there's Griffin Underwriting versus Varasakis in 2019. And for 2 years, up to 2020, she's been acting for Her Majesty's Treasury in relation to its long-running dispute with Bank Milat. So I'm now going to hand over to Philippa, and I think you're going to be focusing on some of the charter party or potential charter party issues which may be coming up in the next few years on.
Simon, that's right. Thank you very much for the kind introduction. Thank you very much for inviting me to come and speak at this seminar today. One of the joys of events of this kind is that we're able to bring together participants from the world of academia, from legal practice, and indeed participants from all around the world, which is one of the reasons that these events are so valuable, I think. I'm just going to try to share my screen. So if you would all hold your collective breath while I do that. Has that worked? No. Yes, maybe. Yes? Simon, you're on mute. Can you nod?
It just needs to be, I think, needs to be bigger.
Okay, how do I do that? Press
the wine glass at the bottom. There we are. Yes. That's the wine glass.
Is that better?
Yes.
Okay, good. Now, I hope I'll be able to make that. Yeah, that works. Hooray. Thank you. Sorry. Should be used to this by now is the truth, but I'm not. So on your screen, you should see a picture of 3 vessels, and those are 3 vessels in the cruise maritime voyages fleet. They illustrate, I think, what an extraordinary time the shipping industry has had over the last 18 months. These vessels were under bareboat charter from another well-known player in the cruise industry, and CMV went into insolvency in the summer of 2020 because nobody was able to go on cruises anymore anywhere. All these vessels were the subject of court-ordered sales, and 2 have now been scrapped. They have found their way onto the breakup beaches in Alang in India. A sorry tale. In contrast, as we all know, other sectors of the industry have kept on going, and they have kept food on our tables, and they've kept oil and coal in our power stations, despite a year and a half of unprecedented difficulties. And as Simon has said, I'm going to focus on charter parties today. And in the course of my presentation, I'm going to look at 3 areas. First, I'm going to consider the sorts of issues that have arisen. Secondly, I'm going to look at the attempts that have been made so far to deal with those issues by way of clauses in charter parties. And thirdly, I'm going to touch on what we can expect in the future in that respect. As an English lawyer, I'm necessarily focusing on English law, but it's fair to say that these sorts of issues are being replicated all around the world. So first of all, what have we learned so far? What are the sorts of areas where disputes have arisen? Now, before I start discussing those areas, just a word of warning. If you're looking for cases on all this, you won't find them, or at least not yet. And that's because of the way in which things travel up the legal food chain, or perhaps down the legal food chain, depending on your perspective. Owners, charterers, P&I clubs have been grappling with the sorts of issues I'm about to describe day in, day out for the last year and a half. In most instances, they will have reached pragmatic solutions, but sometimes they haven't, and we know that. And those disputes are now at the stage of having been passed or being passed to solicitors. Some of those then find their way on to people like me, but any resolution of disputes is likely to be in arbitration because most charter parties contain arbitration agreements. And it's only therefore if there's a challenge under section 67, 68 or 69 of the Arbitration Act that they will surface in court. So there are going to be cases dealing with these issues, but they're not likely to get there until 2022 at the earliest, and possibly considerably later. So what I'm about to say is not based on an analysis of any judgments, because we haven't got any yet. It's based on discussions I've had with people in the industry and also with information that's generally available. So on this slide, you can see what I see as the key areas by way of headline points: nomination of ports, force majeure and frustration, responsibility for delays, crew-related problems, certification requirements, and post-fixture problems. And I'm going to touch on some of those in slightly more detail. So first, nomination of ports. Issues have arisen, or there have been discussions about safe port warranties, usually, of course, in time charters, because there usually aren't safe port warranties in voyage charters, at least where the charter is for a voyage to a named port. And one of the questions that people talked a lot about at the start of the pandemic was, does a COVID outbreak make a port unsafe? And at the outset, there was quite a widespread view that it probably did. That view, I think it's fair to say, has changed, not least because COVID is everywhere. So any port is at risk of having a COVID outbreak. And indeed, measures have been taken, as we know, to make ports safe, to make places safe where there is a COVID outbreak. And we know now that there's a lot you can do to stop COVID getting onto a ship. If there was some unusual risk of detention at a particular port, over and above what is now a pretty routine quarantine requirement, then I can see that there might be a case for saying that a port was unsafe. But generally, I don't think that's going to be an easy argument to run. Also, at the outset of the pandemic, people got very excited about frustration and force majeure in the context of charter parties. And a lot of people wrote articles. And indeed, I might even have been guilty of doing that myself. But in fact, the way in which things have turned out, this has also been a bit of a non-issue. COVID-related delays, well, they're unlikely to frustrate a charter, not least because they're all too foreseeable now, I'm afraid. So they won't satisfy the ordinary test for frustration. Force majeure clauses, well, in theory, you might have a force majeure clause that exempts one party from performance or excuses a delay in performance where there's been a COVID-related delay. It will, of course, be a question of construction of the relevant clause. Usually there's got to be some sort of causal connection. We know that from the classic maritime case. And in instances where delays or issues could have been reduced or mitigated by the taking of particular measures by the party trying to rely on the clause, they won't have any joy. And that's the Channel Island Ferries and Sea Link case. So a force majeure clause might help a party to a charter party, but it's all going to depend on the wording. And in my assessment, probably it won't be a bit of an issue. On the other hand, these are areas where we are seeing real issues. We have seen them, we are continuing to see them, and we will go on seeing them. And it's the two areas on this slide that I see as the big points, really. The first is responsibility for delay. We all know that COVID has had a huge impact in terms of delays in the performance of charters. And of course, that gives rise to different issues in the context of different types of charter. In voyage charters, there have been major issues, and Regina's already touched on these, around the giving of notice of readiness. Can you tender notice of readiness if the ship has got to quarantine before she can berth? Can a master give notice of readiness if he knows that there's a possible COVID case on board his ship? Does he have to get his crew's lateral flow tests back before he can tender notice of readiness? What about free pratique? If you've got a WIFPON clause, does it make a difference? Those are all questions that are out there, and I'm really throwing out questions rather than giving answers, but they give you an indication as to where debates are likely to rage in the future. In time charters, off-hire is likely to be the big issue. Is a vessel off-hire when she's got to quarantine? Well, based on the Laconian confidence, if the issue which is causing a delay to the vessel arises out of the vessel or her crew, then yes, there is a good case for saying she will be off hire. So for example, if she's detained because half the crew are down with COVID, then there may be an off hire question. If, on the other hand, the vessel is off hire because she's quarantined because all vessels coming into the port are quarantined, as is now standard practice, then I would say no, probably not off hire unless there's a particular provision in the charter. But who's paying for delay? That's going to be a really big issue for some time to come. And we'll come on to how charters are increasingly trying to deal with that sort of thing. The second big area, and again, this chimes with what Regina's already said, is crew-related problems. Now, obviously, the biggest crew-related problems are problems for the crew. There have been plenty of articles highlighting this and pointing out that there has been a real humanitarian crisis in relation to crews, and that is absolutely right. Vessel crews in commercial shipping in particular are the great invisible industry. They do make the world go round, and they have been having a really awful time, and anything that can be done to highlight the plight of crews has got to be good. And it actually makes talking about the impact of crew-related problems on charters seem rather small beer. It's in a sense only money, but nonetheless, these are issues which have been taxing the minds of owners and charterers and their lawyers. Crew-related problems cause contractual problems as well. For example, can you redeliver a vessel under a bareboat charter if you can't get your crew off? What happens if a crew member is sick and you have to deviate? The answer is, well, deviation is almost certainly allowed for the purposes of saving life. And so a vessel probably won't be off hire or be regarded as having deviated illegally if that happens. Crew changes, I'm going to come back to. Crew changes have probably been the single biggest issue arising out of the pandemic. It's been much harder to effect crew changes because of delays and quarantine. Some ports have refused to allow crews to disembark at all. And that has meant, as Regina has already mentioned, that an awful lot of crew members, it's a vast number, have been staying on their vessels when they should have been on leave and they should have been able to go ashore. And that has caused major difficulties, and it's caused difficulties for the operation of charter parties as well as for the crew members themselves. The next area I'll deal with shortly, certification requirements, fairly self-explanatory. There have been delays in relation to the expiry of certificates and difficulties of renewal, leading to issues with breaches of charter. And then post-fixture problems, the impacts of a previous fixture on a later fixture. If a vessel's been delayed because of quarantine at one port, that can have a knock-on effect on her next fixture. If there have been concerns because of somebody's had COVID on board, that can have an impact on the next fixture. And then there have also been delays in the usual admin you have when a fixture is finished. Typically, for example, compliance with demurrage claim requirements. Demurrage time bars are, of course, notoriously very short, very strict. You have to put in all your supporting documents in support of your claim. Well, that can be a bit more difficult when everything's slow and difficult because of COVID. So that's an area where there have been issues and where I think there will continue to be issues. Well, it's all very well me banging on about issues and saying issues, issues, issues. What do you do about the issues? Well, as with anything contractual, the answer is going forward, you make provision in your charter to deal with those issues. It's a contract. So at least in theory, the parties can do whatever they like. They've got freedom to contract. But of course, what they do and what in practice they can do is going to depend on their bargaining power. And that bargaining power has fluctuated very interestingly, to my mind, over the course of the pandemic. So think about the markets. What you can insist on in your charter depends on your position in the market. And the shipping market, of course, isn't one big market. It's lots and lots of little markets. And where you are in your particular market depends on who you are. Cruise vessels, well, we've seen that at the beginning. Nobody wants a cruise ship just now, I'm afraid. So if you are an owner in the cruise market, you are not in a great position at all. Yacht charters, similarly, another part of the leisure market, it's a charterer's market. The owners are putting their foot in the water, excuse the pun, cautiously again. People are starting to think about chartering yachts, but they're also very, very wary and they're concerned that they might have to cancel or change. So it's very much a charterer's market there. Container vessels. At the start of the pandemic, the market plummeted and it is now at an all-time high because of consumer demand resulting from lockdown and now from the opening up of the economy. So charter rates on container vessels are as high as they have ever been, and there is a tendency to fix on longer term charters. So that means we had a charterers market where charterers were able to insist on particular terms, but that's changing now, and we're going over to an owner's market, and I think that's going to have an impact on what we see in charters. Dry bulk plummeted at the start of 2020 and then rose sharply in the second half and basically continued to climb. Heavy lift, very, very high charter market at the moment. June has seen record highs for break bulk carrier charter rates. Tankers, of course, are special because they're so linked to the price of oil. There was a drop in global demand in the first quarter of 2021 and rates are now picking up. So that's a kind of industry angle rather than a legal angle, but of course the two are interrelated, and it matters, as I say, because it impacts on what parties can ask for and insist on in their charters. And that brings me on to what has been happening. So firstly, on the ground, attempts that parties have been making in relation to specific clauses to try and deal with the problems as they see them arising out of the pandemic. And these are just some examples of what parties have been trying to insist on. Early on, in particular, we saw what I would describe as some uncomfortable trends. So insistence on health screening warranties, charterers requiring owners to warrant effectively that their crew would pass COVID tests, and stipulating that owners would meet the costs of delays if they didn't. Secondly, the notorious no crew change clauses. Now, these are nasty, I'm afraid. These were and are clauses that charterers were insisting on, requiring that there would be no crew change effected during the currency of typically a short time charter, or a time charter trip or a longer voyage, but really time charters. And owners were being put under considerable pressure to agree to those clauses because of the difficulties that I've already described arising out of crew changes. And one can readily see those were not good. They were not good from the perspective of crews, and they were not right. And the IMO and the International Chamber of Shipping have come out very strongly against those no crew change clauses, and in my view, rightly so. Say a little bit more about crew change clauses in a moment. Compulsory vaccination clauses, that's something that in a sense has already been touched on because of the discussion earlier this session about vaccines. I can see there being all sorts of interesting arguments around this. I can, not yet, but in due course, I can see charterers requiring or asking that a clause be included, requiring crews to be vaccinated, particularly in the leisure markets where one can see that there's contact with members of the public. And that gives rise to all sorts of potential issues, both in relation to the charter parties themselves, but also in relation to the crew and their employment contracts and how it's actually all going to work. So that's not now, but that's something I can see coming. So those are the on the ground clauses, if you like. What about the wider industry bodies? As Regina mentioned earlier, there have been some attempts at drafting clauses, or indeed at making use of clauses that are already there. And of the clauses that are already there, the most well known is the BIMCO, infectious or contagious diseases clauses. This is quite an old clause, I think, set of clauses. There are two, one for voyage charters, one for time charters. They were developed in, I think, 2005, at the time of the Ebola outbreak, the first Ebola outbreak, which was, of course, confined to specific areas. I've summarized on this slide the way in which the clauses work. The difficulty with them in the present context is they don't really work where you've got a global pandemic, because they hinge in particular on there being an affected area. Now, at the start of the pandemic, there were just some affected areas, and so that kind of worked. But now, of course, everywhere is an affected area. So having a clause which applies to affected areas isn't really going to inform anyone very much. And BIMCO are very open about the fact that this clause is not really fit for this particular purpose. Might still work for other diseases that are localized, doesn't really work for COVID. I'll come on shortly to what they're trying to do about that. Intertanko, tanker industry body, came up with its own clauses very, very early on. These clauses, they're an example of the kind that Regina mentioned earlier. They are hugely owner friendly, as you can see from the summary on the chart, or on the slide. And so while the market is in owners' favour, owners might be able to insist on these clauses, but so long as charterers have the whip hand, they're going to say, no way, because the effect of these clauses is to place all the risks arising from COVID on charterers. And that's not very attractive if you are a charterer. One clause which has cropped up to deal with that particular issue is a very niche one, and this is the Marine Yacht Brokers Association COVID addendum, which they put in circulation very early in the pandemic. The MYBA is the main is the main industry body in the oh help, I'm going the wrong way. Now, sorry. Let's go back. My faults. Okay. So the MYBA is the main industry body that promulgates clauses. They promulgate the main charter form that is used in yacht chartering. It's a horror of a form, I have to say. It's got all sorts of issues. And I don't myself think that this addendum is brilliantly well drafted either, but it is quite interesting as a specific attempt to deal with the problems arising out of COVID. It allows either party, owner or charterer, to give notice before the charter period if, in effect, they think COVID is going to have an impact. It triggers an obligation to have good faith discussions, which 20 years ago would not have been seen as an enforceable obligation. I think it now probably just about is. And if those fail, either party can cancel if and all monies paid are returned. So that's quite charterer friendly. Termination during the charter period as a result of COVID, it essentially depends on who got it first. If it was crew, then owner is going to bear the risks. And if it was the charterer or charterer's guest, then charterer is going to bear the risks. Interesting, I think, as a specific attempt to deal with a specific problem, even if not perhaps a fabulous bit of drafting. Another very specific clause brings us back to crew changes. And this is the BIMCO crew change clause for time charter parties, developed last June, specifically to deal with the problem of the no crew change clause, to which I've already referred. And BIMCO said and continued to say, look, we recognise that crew changes are a real issue, and they're a real issue for both parties, but it cannot be the case that the owner has to bear all the risks of crew changes. It is not fair, it is not commercial, it is not pragmatic. And so they have developed a clause which they see as fair. It gives an express liberty to deviate for crew change. The vessel remains on hire, but at a reduced rate to be agreed, or is off hire. And there's a choice. You can choose which one of those you go for. It is meant for longer term time charters only, although the right to deviate must be incorporated into subcharters and bills of lading to ensure that the crew will actually be changed. And I think myself, it's a very good clause. It's a very pragmatic clause. It is there to deal with a real problem, and it is a good faith attempt to balance the interests of owners and charterers, which can sometimes be opposed. So that's what has happened so far in terms of bespoke clauses. Where do we go from here? Well, the answer is that BIMCO are working on a set of new clauses at the moment, which are intended to effectively to replace the infectious diseases clauses for the purposes of the pandemic and future pandemics, because nice as it would be to think that this is the last, we'll probably know that it isn't. They are focusing on definitions of disease and affected area, which are the triggers for the current clause. They recognise, as I've said, that the affected area wording is not working at the moment. They recognise that the biggest problems are around delays rather than around infections of crew. The old infectious diseases clauses are focused on the worry about people on board the vessel actually coming down with the disease. BIMCO recognise that actually you can deal with that. You can put measures in place to stop people getting COVID or at least reduce the risk, but they recognise that there are big problems around delays, and that is what any new clauses are going to be geared to. They say one's got to recognise that the risks of those delays must be shared between owners and charterers. But what they're saying at the moment is the challenge is to come up with a clause that is fair to both owners and charterers, and that the markets will accept, because there is no point in having a standard form clause if nobody is prepared to adopt it. There is no point in it at all. And at the moment, they are struggling to come up with wording which is acceptable to all sectors of the industry. So I checked in with Grant Hunter, who's the BIMCO contracts wording chap, last week, and he said that they have had drafts in circulation amongst a small number of people, but they have a long way to go, because it is difficult to come up with wording which does satisfactorily reconcile the interests of both owners and charterers. I think that is interesting, and it remains to be seen whether they're going to be able to do it, because it is quite a challenge, I think. And my final picture is just to remind you again, as if you needed reminding, of the people who have borne the brunt of this in our industry. It's the crew. Owners and charterers have had a difficult time, but it's the crew issues that I think have really taken everybody by surprise, and perhaps not in a good way. Thank you very much. As Simon said, probably sensible to take questions if there are any at the end, and I shall stay around to listen with interest to the presentations of the other speakers. Thank you very much.
Thank you very much, Philippa. That was a an excellent presentation, very interesting. And I have to say also that I followed a previous presentation of yours back at London Shipping Law Centre back in January and found that extremely useful as well.
Thank you very much.
I've been tearing my hair out for, I'm finalising my draft for the UNCTAD report for Regina, and she keeps asking me about, can we draft clauses which are fair to both parties? Yes, I'm finding that difficult to come up with suggestions on that, but maybe, hopefully Grant will get somewhere with that, maybe not. Now, I now am in the unusual position of having to introduce myself as the next speaker. So I'm Simon Bourne. You've actually got the pre-1750 spelling of my name up there. It is actually Baughen. One of my descendants started out as an AN and ended up as an EN, but that doesn't matter. I've been at Swansea as a professor since 2013, interested in maritime law generally, although I have also been researching into things like climate change and transnational liability of multinational corporations. Before that, I was at Bristol for about 24 years, and before that, I was a shipping solicitor with Horrocks & Co. You won't find them around anymore. They ceased to exist shortly after I left, or there was no causal connection. So I'm now going to do my share screen, and it's going to be about COVID and carriage of goods. So we're going to look at really the bill of lading, potential issues. Right, so I've come right to the end of my presentation, so I shall quickly whiz through to the beginning. I can get there. Yes. No, it seems. So I'm going to look at contracts for carriage of goods and principally these issues: delay, who is bearing the cost of redirection under Caspiana clauses, a quick look at the issue of container demurrage, where there may be difficulties getting your containers back for the ship owner, and you may end up facing quite a bit of container demurrage, deviation, and then delivery of cargo without presentation of bills of lading. And I'm just going to set myself a little timer reminder to make sure I don't overrun. So delay is the principal effect which the pandemic has had on carriage of goods by sea. Delay through quarantines, whether they are generalized quarantines, whether they're quarantines because your ship has come from a particular place. That was particularly common early on in the pandemic. And then quarantines because the crew get tested and you then find that the crew, or some of them, have got COVID-19. So substantial extra time due to quarantine, but also the process of loading and unloading ships has, I think, been extended. You saw at the end of Philippa's slides a picture of people in these COVID protective suits. I mean, this is all going to sort of cause extra time, and it's not, things are not going to run as quickly and smoothly as pre-pandemic. Delay, I'm principally going to talk about physical damage, basically deterioration of cargoes because it's been taking longer to complete discharge. You've got substantial waiting outside the port due to quarantines, and then perishable cargoes can deteriorate. Who's going to be liable for that? Is the ship owner going to be liable? So taking the Hague and Hague-Bisbee rules as as an English lawyer, I'm afraid I am going to focus on English law. So if anybody was hoping for a discussion about the Hamburg rules, I'm afraid I'm not going to be able to have time to do that. But the basic scheme is, under the Hague rules, if the goods are okay on loading and the bill of lading says loaded in apparent order and condition, and when they come out the other end at the port of discharge, they're either lost or damaged, there is a presumed breach of Article 3, Rule 2, unless you can, as the ship owner, rely on various exceptions. And those are provided in Article 4, Rule 2 of the Hague and Hague Lisbon rules. And again, and also bear in mind that if there has been a breach of the seaworthiness obligation under Article 3, Rule 1, the owner will then have to prove that they have taken due diligence to make the ship seaworthy before they can rely on those exceptions. So unseaworthiness is going to be a particularly important aspect, particularly unseaworthiness due to the crew perhaps being infected with COVID at the start of the voyage. So it's leaving aside just a moment the question of unseaworthiness due to potential crew infection, physical damage. The ship has taken longer to get the cargo off. There's actually been a recent demurrage case called the Eternal Bliss, which was involving a cargo of soybeans, which there was a 31-day delay in getting into berth at the Chinese discharge port, and it was alleged that because of that delay, the cargo deteriorated. And I'll come back to that one possibly a bit later, but that's the type of claims which I think we might see as regards cargo claims. There are various exceptions which, absent any finding of unseaworthiness, should be able to be relied upon by the owner. Arrest or restraint of princes, rulers or people, or seizure under legal process, well, I think quarantine measures could well be regarded as restraint of princes. There's also a specific reference to quarantine restrictions. There is some sort of slight uncertainty as to whether these actually can be relied on in relation to pre-existing quarantine situations. There's certainly dicta in a case called Chiampa, which suggests, and this is to do with the common law defense of restraint of princes, that if the restraint is already in existence at the time you set off on your voyage, and it's therefore foreseeable, that is not something you can rely on. That has actually received adverse judicial commentary subsequently in the Reardon Smith and MAFF case in the early 1960s. But there's also, I think, the Q defense could well come in. Any other cause arising without the actual fault or privity of the carrier, or the actual fault of the agents or servants of the carrier, with the burden of proof being on the person claiming the benefit of the exception to show that neither the actual fault or privity of the carrier or his agents or servants contributed to loss or damage. And if you've got a straightforward quarantine because that's what the port is doing as a matter of course, I would have thought that would be an applicable defense. But there's also the other possibility, and somebody, I saw a presentation earlier suggesting that in the new normal, that you wouldn't be able to rely on these defenses. I think going back to the point I mentioned earlier, but you wouldn't be able to rely on these defenses if these delays are now foreseeable and part of the new normal. Well, as regards to deterioration, I would say actually you probably have an inherent device defense, because why, if you know that it's going to take X amount of time now in the new normal to get your cargo of soybeans over to China and discharged, And actually, it's going to take longer than that, and that you know the cargo is going to deteriorate because of that extra time. I think there's a good argument that the inherent vice defence might kick in, particularly. Well, we may have arguments based on what was happening in the Maltesian with that cargo of fish, which was inevitably going to go through the Mediterranean, come into higher temperature waters, and then would be subject to bacterial infection. And the ship owners were not obliged to install refrigerated facilities to carry that fish. They just did what the shippers instructed them to do. So I think possibly the queue defence may still be important. I would also quickly change horse, if I may, about. No, I'm not going to change horse because my horse is running away with me. This is the case I mentioned, the eternal bliss. That is a sort of factual situation which could be arising with COVID, i.e. our cargo's deteriorated because we have this extra waiting time at the port due to quarantine. Well, absent any breach of the seaworthiness obligation, I would have thought, again, you would have a queue defence, and that's one of the peculiar things about the eternal bliss is why the poor old owners actually ended up having to pay $1 million to settle that claim. But I won't speculate any further on that. Unseaworthiness, of course, changes the matter. You can have unseaworthiness due to crew illness. Now, and a case which a lot of people refer to, it's not to do with crew illness, but it's to do with the fact that the ship has previously been at a port where there's plague, and then under the new voyage, she's going to call at, I think it was a French port, Marseille, and it would be inevitable, because of her previous trading to that plague port, that there would be fumigation, and there was fumigation. And that was not good news for the cargo of lemons which was being carried on the vessel. That meant that the ship was unseaworthy when it started the voyage, because it was inevitable that during the voyage when it called at Marseille, that it would be subject to fumigation, and that would damage the cargo. By analogy, I think if you've got a ship which starts out with COVID crew on board, that's going to get picked up when you get to the port of discharge. You're going to have extra quarantine time as a result of that. Now, if that extra delay is the cause of your deteriorating cargo, then you're going to be liable. I don't think. But again, it's got to be the cause of the deterioration. What about the due diligence defence? Remember, this is a non-delegable obligation. That's the Muncaster Castle. I wonder how this actually would work in practice. Certainly in the early part of the pandemic, I think getting testing kits was actually really difficult. I mean, now it seems, you can get them over the counter. The government is telling us, we can get 2 tests a week of lateral flow if we want to. And I think it's now probably very easy for ships to at least to have lateral flow tests for their crew. And they should be doing that. But and there's also the other possibility early on in the pandemic of crew going ashore and then coming back on, having gone to the nightclubs of the various ports and having contracted COVID there. Does that mean, because have they been careless? Have they carelessly made the ship unseaworthy because they've now got COVID and they go on board it. It's a non-delegable obligation. I think it goes right down through to the servants and agents of the carrier. I'm thinking of the CMA CGM Libra case recently. The other unseaworthiness, which may not be causative of delay loss for carriage of goods, but is certainly going to cause all sorts of problems under time charters, is where the crew are at sea in excess of their maximum period of service under the Maritime Labour Convention. I say this because the risk is of detention. The principal obvious risk is detention. And some ports, particularly in places, Australia, have been detaining vessels where the crew have been in excess of their maximum service period. I think that will happen after discharge of the cargo. So I don't think it's going to be something which affects cargo claims, but it's certainly something which is going to cause issues for time charters. You could also be, if the crew is at sea for a very, an excess time, they're not going to be perhaps as good as they ought to be. And that may result in general maritime accidents, and you may not be able to rely on your, if you've got a collision, your defense of nautical fault, because you've got an unseaworthy, the crew tired and inefficient, and that has caused the collision and the loss which is thereby suffered. So that's a potential incidence of unseaworthiness. Now, I've just reminded myself I've got 5 minutes to go, so this may be a whistle-stop tour. Economic loss, it's nothing really under pure economic loss. The loss of delays, due to delays, I think there is an implied obligation to proceed with due dispatch, but not a specific Hague Rules obligation. I'm going to first of all, redirection clauses, very common with particularly container bills of lading, and these are permitted under the case of Renton and Palmyra. They don't go against the Hague Rules scheme. They're regarded as clauses which define the voyage which is being undertaken, rather than exceptions clauses. This is the strike case where there was a clause saying that if you can't get to London because of a strike, you can go and discharge elsewhere. And that's what happened. They discharged on the continent. The clause is not invalidated by the Hague Rules, Article 3, Rule 8. The parties have freedom to negotiate what obligations the ship owner is undertaking. But there are a few qualifications which could be important if these clauses get challenged, because cargo consignees are getting a little bit fed up with it's the commercial convenience of the container line. Oh, we'll just discharge your cargo somewhere else. And this has actually been one of the knock-on effects, particularly in the last autumn. Felixstowe was getting very, very crowded, and container lines were redirecting first to other ports in the UK and then to ports on the continent. And I think there was similar redirection going on in China due to congestion at Tianjin. Just a few salutary points from Lord Somerville. The master must act reasonably, and he must have regard to the consignee's convenience as regards the ships. And also Lord Kilmuir is talking about the clauses which are applicable and operative only in the event an occurrence of certain specified emergencies, talking about the event of obstacles beyond the control of either party arising to prevent or impede the performance of the contract in accordance with its primary terms. I can foresee potential arguments about how these clauses operate in the context of redirection during the current pandemic. Now, I'm going to... there's also potential problems with container demurrage. Remember that the original shipper remains liable under a bill of lading. And if you have a situation with abandoned cargo, you can end up with substantial container demurrage. MSC and Cottonex is the case on that. And actually, I think it was about 8 months before the contract was finally regarded as having been brought to an end. 8 months of container demurrage is quite a large bill for the shipper to face. The consignee had abandoned the cargo. I'm not sure whether we've seen abandonment of cargoes actually happening, but it's certainly been something which people have been speculating about as a potential, particularly if you have consignees becoming insolvent and going out of business. Delivery of cargo without production of bills of lading. I think we're going to have more of that sort of situation. You've got the standard solution of giving a letter of indemnity. You're not going to have your P&I cover. But of course, the letter of indemnity is only as good as the person giving it and what happens if they go insolvent. And I believe there has actually been one case involving insolvency and of a provider of a letter of indemnity, the Tenacity Maritime claim, which happened earlier this year. The last thing I'm going to mention, though, is one potential issue with the BIMCO and Intertanko clauses for the charters. Both clauses require that they be incorporated into the carriage documents. And what you've got, I think in both of them, it's clause 3, which is the thing about charterer's indemnity. Now, what I'm wondering is, if you've got a clause in a bill of lading saying BIMCO infectious diseases clause to apply, are the courts going to manipulate the language of that clause when it's incorporated into the bill of lading, in the way that if you have, for example, in the Channel Ranger, you're specifically incorporating the arbitration clause, I think it was, of the charter party. In fact, there's no arbitration clause, but bit of linguistic manipulation, we bring in the jurisdiction clause. I'm just wondering whether there's a risk that those indemnity provisions might, the wording charterer might also be extended to the bill of lading holder. So if anybody wants a potential new claim, I'm just throwing that one out for consideration. Of course, I may be overthinking the matter and being rather devious. I'm going to have to bring myself to an end, but before I do so, two things. This is a bit of a flyer for our next webinar, 30th of June, on flag state jurisdiction and protection of merchant vessels, revisiting the Enrique Lexi Award, and that's the link. And that's me done. So I'm now going to hand over to our third speaker, who is the IISTL's own Dr. Leah Amaxilati. And I'm going to stop screen sharing, which is always good. And so Dr. Amaxilati joined us at Swansea in 2019. She recently completed her PhD, and she specializes in admiralty, maritime labor law, and personal injury claims. Before she joined us at Swansea, she was working as a lecturer in private law at Queen Mary University of London, and was also a tutor of law at the University of Southampton. And she taught admiralty law at LLM level there. She's also a qualified lawyer in Greece. So Leah, I'm going to hand over to you now.
Thank you, Simon. So let me share my screen. Okay, great. So thank you very much for the introduction. It was actually really interesting to hear that most of the previous speakers have highlighted and drawn some attention to the important role that seafarers have played throughout and continue to play throughout the pandemic, and also the fact that they highlighted the serious difficulties and issues that they have encountered the past 15 months. So I think almost everyone recognizes how tremendously the working and living conditions on board ships have deteriorated since the beginning of the pandemic. Like basic rights, like the right to join or leave a ship, the right to medical care, the right to shore leave or annual leave, and sometimes even the right to adequate provisions or necessary medication have been challenged. It is true that, and I think Dr. Azariotis mentioned that in her presentation, that the IMO, the ILO, the International Chamber of Shipping and other stakeholders have cooperated and have done a tremendous effort to deal with this situation. However, many of these issues continue to affect the working and living conditions of seafarers. And so basically my presentation today will try to give some the perspective of the Maritime Labour Convention to some of these issues, and perhaps we'll add things to what the previous speakers have said, and perhaps we'll give some opportunity for further discussion during the Q&A session. So the first part of the presentation will basically consider the position with regard to, the position with with regard to the provisions of the Maritime Labour Convention, which provisions were affected, after 1 year, can we say that the provisions of the convention are adequate to deal with this kind of situation, or perhaps we need to have some amendments, or perhaps add some new standards to deal with the current crisis, or perhaps be better equipped for the future. And then in the last part, I will deal with some topics that have been mentioned earlier, but as I said, from the Maritime Labour Convention perspective, like the seafarers vaccination and the no crew change provisions. So to begin with, the provisions that have been the main concern during this last year. Well, obviously, regulations 2.1 and 2.5 of the convention with regard to the extent of the seafarers agreements, employment agreements, and the seafarers' right to repatriation have been in the center of the attention. And Article 3 of the Maritime Labour Convention, which basically requires member states to take measures to and take provisions to respect the fundamental right to eliminate forced or compulsory labor. Article 1 of the Maritime Labour Convention as well, which basically requires member states to cooperate in order to ensure the enforcement and implementation of the convention. Chapter 5 of the convention, which basically sets out the provisions with regard to flag state inspections and port state inspections. At least for the first part, the first 6 months of the pandemic, inspections have been, in many situations, inspections have been suspended. And this actually raised concern as to whether the safety levels required are maintained on board vessels. Article 4 and Regulation 4.1 and 4.2, which deals with the medical care and health and safety on board vessels, have also been crucial. Standards A 2.7, which deals with the minimum requirements with regard to manning of vessels, and also the regulations with regard to medical certificates, training certificates, and the certificates with regard to the compliance with the MLC requirements. Now, these are the main provisions that have been challenged the past year. Now, and they are mainly the provisions that have been discussed by the Special Tripartite Committee of the Maritime Labour Convention at the end of April 2021, during their 4th meeting. Now, the general consensus is that while the substantial obligations under the convention seem to be adequate, the main issue comes when it arises from the implementation, enforcement, and application of these substantive obligations. So what we basically have seen the past year is that the implementation system has not been consistent through in different member states, and also the enforcement have been widely the enforcement provisions have been widely disregarded in that sense. So the discussion basically is as to whether we would need to have some changes, perhaps in the standards of the convention, in order to ensure that the implementation and the enforcement aspects would be more efficient for the future. There's one of the things that has been pointed out is that although the convention includes provisions with regard to the consequences that perhaps seafarers would have if they don't comply with their obligations under the MLC, there is nothing in the convention that provides for any consequences to member states, perhaps, if they don't comply with their obligations under the convention. So there is a discussion as to whether there needs to be an amendment in this regard. There is also some discussion as to amending some of the inspections provisions. During the pandemic, many states had swifted or tried to shift towards some electronic documentation in order to facilitate port state inspections and flag state inspections. And there was a discussion as to whether this would be appropriate in view of the provisions of the convention. So there is also some discussion in this respect. And one of the issues that will probably be clarified is with regard to the maximum period of service for seafarers, because the convention was not particularly clear in that respect, based on the combining reading of regulation with regard to the Seafarer Employment Agreement and the regulation with regard to repatriation. It was possible to assume that the maximum period was 11 months, but I think perhaps after the next meeting, that would be clarified and perhaps be incorporated in the convention in a clearer way, because the way the convention is drafted right now, it does give some space for manipulation. And one last issue that I will talk about that later as well, is that the convention does not include anything with regard to vaccination, obviously not just for COVID, but in general. It does include provisions with regard to medical care. So there is a question as to whether there needs to be any change to cover vaccination for seafarers as well. So moving to the vaccination topic. Now, I know some of these things perhaps have been mentioned earlier. I would particularly like to draw your attention to the resolution that was adopted by the International Labour Organization 2 months ago in April 2021, where the issue of vaccination was discussed, and basically the resolution requires states to cooperate in order to establish the most efficient way to vaccinate seafarers and proceed with the rollout of vaccines for seafarers. It was particularly interesting that the suggestion that had been made by the government representative of Cyprus, that the attention should be given to seafarers that are ashore before they are joining their vessel, and then the vessel should be treated basically as a bubble for COVID purposes. So this was one of the recommendations that has been made. Obviously, we realize the difficulties that exist with the 2 different doses of the vaccine, the fact that the seafarers should be the 2 doses needs to be provided with a distance of about a month, perhaps. So that's why they recommended that perhaps dealing with that before joining a vessel might be more efficient. And I think, as it was mentioned at the beginning, we are still at a stage where the vaccine rollout is basically controlled by states. So although there has been some discussion as to whether ship owners can vaccinate, can start the process to vaccinate their crew, we're still not there. And I think mainly this is because of the supply issues when it comes to vaccines. Now, 3 questions that are particularly interesting from the maritime labour perspective is: can a ship owner require seafarers to get a COVID-19 vaccine? Well, as I said, the Maritime Labour Convention does not provide anything in this respect, does not refer to vaccination at all. So clearly we cannot answer this question based on the provisions of the convention, and it is more likely that national law would deal with this question. Now, as far as English law is concerned, it is highly unlikely that such a requirement can be made. Well, of course, the ship owner is under a duty of care to take reasonable measures for the safety of the crew on board the vessel, but it is highly unlikely that this will cover anything more than a recommendation or perhaps the sharing of some information with regard to vaccination. And of course, different approaches might be taken by different governments, but at least in the UK at the moment, vaccination against COVID is not compulsory. So this also stresses that it's highly unlikely that it would be possible for ship owners to require that based on national law. There is, of course, the contractual possibility. And vaccination is something that has been covered by some employment contracts, particularly for vaccines that are required by some port states, like the vaccine against yellow fever, etc. So based on the existing contracts and assuming that the seafarer is under an existing contract, if there is a term in the employment agreement that it is widely drafted, perhaps suggesting that the seafarer agrees to take any vaccinations required by the port that the vessel is supposed to sail during the employment relationship, it might be possible for the COVID vaccine to fall under these contractual provision. But if such contractual provision does not exist already in the employment contract, it would be very difficult for the ship owner to amend an existing contract without the consent of the seafarer. When it comes to new contracts that might be concluded from now on, of course, it is possible to include such a provision. As I said, these provisions have been used before for other vaccines, and they have been considered as legitimate provisions, provided that, of course, the seafarer consents to these provision. If they do not consent, of course, they cannot be forced to undertake any medical intervention or any vaccination, and it has to be the ship owners need to be particularly careful because they need to deal with each situation individually, because depending on the reason why the seafarer does not provide consent for the vaccination, there might be a risk under the Equality Act when it comes to discrimination, perhaps in the workplace, or if they decide to dismiss a seafarer, an unfair dismissal claim in this sense. Now, two other questions that are interesting is the ship owner liable for the cost of vaccinating seafarers, or perhaps for the consequences of vaccinating seafarers if they have any side effects? And would the ship owner be liable in the event that the seafarer refused vaccination and other crew members contracted COVID-19 as a result of contact with the unvaccinated seafarer? Now, as I said, we're not at this stage yet where ship owners are able to control the vaccination program, and of course, as long as the vaccines are the rollout of vaccines is under the auspice of states, of course, they will not, ship owners will not incur any of the costs. But if in the future we reach the point where ship owners require vaccination based on the contract of employment, and if we're at the point where they can provide for the vaccinations, then obviously the costs will be on the ship owners and not on the seafarers. And when it comes to any side effects, of course, if these are if these occur while the seafarer is on board the vessel and in the course of her employment, then Regulation 4.2 of the MLC will be applicable. Now, with regard to the ship owner's liability, if a seafarer contracts COVID-19 because some of the crew members have denied vaccination. Now, again, this will depend. Obviously, Regulation 4.2 would be relevant, and the ship owner would be under an obligation to provide for medical care if the seafarer is on board the vessel. But for additional liabilities, it would depend as to what measures have been taken to facilitate the coexistence of the crew members that had not been vaccinated. Have they done any special arrangements, for example, with regard to protective equipment or social distancing measures, if possible? So again, it is something that needs to be judged on a case-by-case basis. Now, moving to the last point with regard to no crew change clauses, I know that some of these have been mentioned earlier. So I'm not going to repeat. I would just like to highlight the supply chain health checks for seafarers, human rights, and crew change due diligence, which has been published in May 2021, which basically requires for cargo interests, charterers, and ship owners to use their leverage in exercising due diligence in order to ensure that the seafarers' human rights and employment rights with regard to crew changes are not violated. But the main point, perhaps to add to what has already been discussed with regard to no crew change clauses. Now, of course, they can be included, at least there's no, in a charter party perhaps, but when it comes to the obligations of the ship owners under the Maritime Labour Convention, it should be, ship owners should be cautious, because if the crew members that are on board have exceeded their maximum period of service, let's say the 11 months, then this can expose the ship owners to the possibility of breaching their obligations under the Maritime Labour Conventions. And this can potentially affect their ability to obtain the declaration for maritime labour compliance, or the maritime labour certificate. So I think, while there, obviously from the seafarers' perspective, these clauses are particularly unfair, but it can also have further implications when it comes to the ship owners' obligations under the Maritime Labour Convention. And this needs to be taken into account as well before including such a provision in a charter party contract. So thank you very much. And I will be happy to hear any questions, perhaps.
Thank you very much, Leah, for a very, very informative talk. I note one thing which I've heard is that the thing about no crew change clauses may be obviated by charterers just sort of making inquiries before they fix charters. We want to know what your plans are as regards crew changes, or what your itineraries are, so that you may then find that, well, if the ship owner is planning to do some crew changes, well, perhaps, you know, we won't sort of charter that vessel. But it is obviously a very important issue. I've got a couple of questions which have come through on Q&A. I can't, because of time, I can't unfortunately provide opportunity to discuss all of them, but I've got, so one question I'm going to ask Leah, do you think the position of seafarers will change following the pandemic? Do you think there's going to be a change in relation to contracts with their employers, given the difficulties they face? I mean, this is about how, as Philippa was talking about, the risks between charterers and owners sort of changing. What about the dynamics between seafarers and their employers?
Well, I don't think anyone would be surprised to hear that many of the seafarers that have been on board the past year are already looking for different forms of employment, perhaps for the future. And I have seen, I have read something recently that actually the number of people that are considering of changing employment has increased dramatically in the past year. And there is actually a research that is going on at the moment, and perhaps it will be published within the next few months, which tries to evaluate the impact. Because apart from the impact on the and the legal aspect, there is also the impact on the practical difficulties that they had to encounter in their lives. And I'm definitely sure that this would be something that will be negotiated at a collective level, obviously not based on individual relationships between seafarers and ship owners. So it would be interesting to see what the next versions of the collective bargaining agreements would look like, if they would have any terms perhaps that deal with this, the possibility of a pandemic, perhaps in the same way that happened with piracy like a few years ago. So definitely there would be some discussions in that sense, but I don't think it will be at an individual level. It would be at the collective bargaining level.
Great, thank you. Now there's a question directed at for Philippa Hopkins. Obviously, most charter parties were not drafted taking into account the issues that would emerge from a global pandemic. When issues, especially in terms of risk allocation, come before the English courts, do you think that a literal construction will be favoured, which seems to be the most recent trend fueled by the Supreme Court, or can we expect a comeback of more liberal construction methods? So get your crystal ball out. I don't know.
Yeah, that is a crystal ball question, really. It's certainly the case that the current trend in terms of the way in which the commercial court and the higher courts are approaching contracts is to take a slightly more literal construction than was perhaps the case a few years ago. I would say the high watermark of the less literal approach, at least in the post-ICS and West Bromwich area, was the Supreme Court decision in the Rainy Sky, where prominence was given to commercial common sense. There's been a certain amount of rowing back from that with Arnold and Britton and the Wood and Capita decision. Having said that, as somebody who spends about 3/4 of her working life dealing with questions of construction of contracts, I do wonder sometimes whether there is a great deal to choose between all these approaches. And I think there are two things that I would say. The first is that any court is going to start with the words used in the contract. That's always the way that they come at questions, whether they tend to take a more commercial approach or a less commercial approach. You always start with the words, and that is not going to change. The second observation I would make, and this is perhaps a slightly cynical one, is that in my experience, judges and arbitrators, for that matter, come to a very, very rapid view as to what a particular contractual provision means. We all do this. We're human beings. We read a contract, we read a term, and we think, well, it means X. And it is very, very difficult to displace that initial view. It's very difficult for an advocate, however skilled, to persuade a judge or an arbitrator to change their mind as compared with that first impression that they formed. I sometimes think that all this talk about approaches to contractual construction is a little bit unreal, because so much of the result in a particular case, when it is about the construction of a contract, depends on that judge's initial impression. And you can throw Lewison on the interpretation of contracts around however much you like, but that's still what it's all about.
Thank you. I've just been typing an answer to another question, but actually I'm going to throw that question over to other people, because there was a question. The very first question we got was about it's slightly off topic, but about the sea mucilage which has happened in the Bosphorus, which gives a possibility of damage to ships. What are the policies applied in such cases? And I think it initially sort of makes me think about unsafe port issues or damage to ships, and it sort of starts to sort of make wonder: is this going to be the next sort of round of unsafe port speculation, like what we had with COVID back in January and February of 2020? It's a very general question. It's slightly off topic, but I mean, I was in the process of typing some sort of response. But I think if either of you two have got any ideas on that.
Well, I would agree that in terms of the carriage contracts, yes, issues of safe ports, unsafe ports are likely to arise. Also, in theory, unseaworthiness down the line, if vessels are going to be damaged, and then if it's going to result in detention, of course, you've got the usual problems arising whenever you have detentions, delays to vessels, and who pays for that. Those are the immediate issues that spring to mind, so far as I'm concerned, though I have to confess it's not an issue I know a great deal about as yet.
Well, let's hope that it's not an issue which lasts for too long and that we don't have to be talking about mucilage in a year's time. I'm just see if there's any further. I think that it actually deals with our questions. So I think probably we will now bring proceedings to a close. And I'd like to thank all the panelists for some really interesting reflections on this dreadful crisis we're going through. I mean, just when you think that the world is about to start vaccinating, you then start having to deal with variants. And you know, I do hope that we won't be having another session like this in a year's time. But so thank you, Philippa. Thank you, Leah, and in absentia, thank you, Regina. And one last thing I would mention with seafarers, on the 25th of June, IISTL's Global Choir for Seafarers is releasing their single, which is a version of the Rod Stewart song, Sailing. And Julian Clark of IISTL has done the sort of groundwork of getting it recorded, and he's done a fabulous lead vocal, and everybody else has been phoning in their recordings of their karaoke singing along to it, and it's going to be this mass global choir of people rediscovering, channeling their inner Rod Stewart. So that is going to, any proceeds from that will go towards various charities to do with seafarers, and it's out on the 25th. So I just thought, I promised Julian I would give a shout out for that, and I know that there's at least one member of the IISTL who has posted in their contribution to that. So with that, I think I will now call the meeting to an end, and also remind everybody that we do have another IISTL webinar coming up in short order on about the Enrica Lexi case, and that's going to be on the 30th of June. Okay, thank you very much for the panelists, and thank you very much for those of you who've attended, and I hope you've enjoyed this this webinar. Okay, goodbye to everybody.
Bye.